are shifting focus to that. Supreme Court has reserved its order in the case. Kapil Sibal represented Justice Varma. A recommendation for removal has been challenged. Sibal said only Parliament can remove a judge. In-house inquiry is only procedural. Justice Datta, as far as the inquiry procedure is concerned, Justice Datta said in-house procedure is the law of the land and the CJI is not a post office. Let me go across to our legal editor Harish, joining us in the broadcast with more details. The interesting arguments taking place. Kapil Sibal, who represented, said that this is just procedural. Only Parliament can remove a judge, to which Justice Datta said that the CJI is not a post office. But most importantly, the order has been reserved, Harish.
Yes, that's right, Swati. After 2 hours long hearing, the Supreme Court has reserved its judgment on the petition filed by Justice Varma in the cash at home scandal, wherein he has challenged the in-house procedure whereby after which he was indicted, and also the communique sent by the then Chief Justice Sanjeev Khanna on May 8th to the President and Prime Minister to initiate his removal. In fact, there were some very significant observations from the Supreme Court bench saying that the in-house procedure is the law of the land, has been following since past 30 years, and also the in-house report is not binding on the Parliament because Parliament has its own in-house procedure as per the Judges Enquiry Act, as per which there will be a full trial and he will be given a chance of hearing. And this was after Kapil Sibal had argued that only the Parliament had power to remove a judge on grounds of incapacity or proven misbehavior. And Justice Dipankar Datta said that this is exactly what the Parliament will do, and this in-house report is hardly a fact-finding document. It's just a fact-finding document, and does not have any evidentiary value. It has only a recommendatory value. And also questioned why, if he is against the in-house procedure, why he did not challenge it at an appropriate time. Why is he coming to the court after the report has been submitted and the indictment report has been forwarded to the Parliament? And despite being a constitutional functionary, why he did not know his powers, that he should have challenged various aspects, including uploading of the video by then Chief Justice Sanjeev Khanna, why he did not challenge the uploading of the video, why he did not come to the Supreme Court to get the video removed from the website, and several other observations where the Supreme Court has said the power to initiate civil or criminal action too, but any complaint if they have to get sanction of the Chief Justice. And Justice Datta said that Parliament has its own power, need not be guided by what Chief Justice or in-house panel said. If inquiry committee is set up, you know who all are its members. Do you think they will get influenced by in-house report or a video uploaded on website by Chief Justice? Also, you did not come when video was uploaded. You could have asked to get the video removed. And also, very significantly, the Supreme Court said,
yes,
if when Kapil Sibal said that he has already been convicted before a trial, the Supreme Court went on to say, if some politician, any parliamentarian says something, even if it is a minister, it matters little. Also, we are not going into newspaper reports that can't be called conviction before trial. So, Supreme Court basically emphasizing that the in-house procedure you are challenging, that should have been challenged at the appropriate time. And if it is a report, the report is just a document. It has
yes, it's not binding on the Parliament. Parliament has its own powers. Harish, thank you very much for putting things into context. Thank you for the update. We're slipping into a very short break. With that, a lot more lined up on the other side.